it comes to our data. And that is also justified because our lives are literally engraved into that data and information. The fear and confusion also stems from the fact that the new Digital Data Personal Act has also come into play. Now, who else, who better to talk about the same than Professor Aafreen Collaco? She is an expert in the field, specializing in privacy and DPDP. Over to you, ma'am. And starting with the basics, what is DPDP and what are the basics essentials like the digital data principle and fiduciary?
Right, thank you so much, Pranjal, for that introduction. So, quickly diving into what the Act is all about, the DPDP Act, and some myths which we are trying to burst around this particular Act. Now, the reason why DPDP Act was passed is to ensure that there is a robust framework which protects our personal data, which could be sensitive personal data also, and it helps us to understand the way data fiduciaries, this is a term which we'll hear time and again when we discuss data fiduciaries under the DPDP Act, in terms of how they are going to protect the sensitive data. So it creates a framework to protect the sensitive personal data of an individual like you and I, and it also ensures that we have some sort of rights and duties to know how that data is being processed, shared and disseminated amongst others in terms of its usage, whether the proper purpose has been kept in mind while that data is being utilized. So it talks about those two sort of terminologies which you mentioned, data principal and data fiduciary. Now, data principal is the person as an individual from whom the data is being collected, right? So there is an entity, for instance, BITS Law School, right? You made an admission into BITS Law School. You become a data principal while you're giving your information like your name, your personal identity in terms of say Aadhaar number, your email address, your phone, contact details, that becomes information of the data principal. In this scenario, data fiduciary would be BITS Law School because they are the ones who are collecting that data and they might go ahead and process that data for a specific purpose.
So, ma'am, where does the state come into play in all this? Because essentially, the data is between the data fiduciary and the data principal, the company and the individual. So, where does the state comes into play, and why is it necessary for the state to come into play?
So the state is governing or ensuring that the way the data is collected from the data principal, the data fiduciary has to keep certain things in mind. Specifically, it has to address why they are collecting the data in the first place. So the state role is through the Act in itself, and the data fiduciary is not limited to just private entities. It can be a state as well. So for instance, there could be a scheme a state introduces for the benefit of the maternity health of a woman. So that kind of scheme, in that sense, if they are collecting that data of women who are pregnant or who are about to get pregnant, that kind of data needs to be protected and safeguarded so that there is no misuse of that information. So the state entities are also liable under the Act. It's not that they are away or they've kept public and private entities away from the DPDP Act.
Okay, so to administer the data, should the state formulate some regulations like the DPDP Act, or should there be a gap between to encourage the capitalistic model and the companies' acts?
Right, so the way the DPDP Act has been implemented is to keep in mind that small businesses are encouraged, not that they are discouraged in terms of collecting that data. See, data is the new oil, that's what we keep on saying. It is basis the data that you can churn out new strategies, you can go ahead and implement some policies because that will give you an idea in terms of how it is going to impact the major sort of audience or your market. So when it comes to the state, the DPDP itself gives you certain regulations as to how that data has to be collected, how it has to be stored and how it has to be processed. So that purpose of the collection of data has to be clearly mentioned by a state entity or a private entity. So that's where the state is taking those regulations in terms of the act which has already been passed by the legislation.
So into this interplay of individual, of fiduciary and the state, and individual's consent also becomes important. So, what's it all about the consent-based approach? Can you please elaborate on that?
Yes, so one of the basics of any data protection law, be it in India or abroad, or the EU GDPR, which we talk about, is the basis of an individual consent. So for the DPDP Act 2023, in Section 6, it clearly lays down that the consent has to be free. Free in the sense not in terms of cost, free in the sense that it has to be without any force or coercion. It has to be informed in the sense that what is the purpose by which you're collecting that data. It has to be clearly mentioned in a clear language, right? Something which is simply understood by a layman, and it should ensure that it should mention the purpose. It has to be that informed consent, mainly.
Correct. So there's also a whole debate about can there be consent in the regional languages when consenting to the data. So can you please?
Sure. So when the idea of consent was being developed in the legislation, we have various iterations of the Digital Data Protection Act, and the previous acts never mentioned the notion of sharing consent in a regional language. So it states very clearly in the DPDP Act that the consent should be mentioned not just in English but in the languages mentioned in the 8th schedule of the Constitution. So any of those regional languages mentioned in the 8th schedule, they can share, or the data fiduciary must share that consent in those regional languages. Looking at the diversity we have in India, it's important, it's rather imperative that those consents are made in a language which is understandable by you and I, and not just English.
Okay, so through those 22 languages, they are going at the ground zero to see that the common layman also understands the consent and the information.
Absolutely.
And you also mentioned the concept of GDPR, and then we have the American concept,
yes,
which is a bit more liberal. So where would you place India's DPDP?
I think the DPDP Act has taken a lot of inspiration from various jurisdictions, not even restricting it to the West. A lot of inspiration from the Singaporean model has also been inspired in creating this legislation. But what we have to keep in mind is the Indian scenario. How does it help specifically businesses, and how is it protecting you and I as individuals when entities are collecting that data? So there has to be a fine balance, and that balance is created through the notion of consent and through the notion of certain rights and responsibilities given or thrown upon a data fiduciary. And I think the Act has done a pretty good job there. Yes, there are certain loopholes, there are certain lacunas we need to work, but that can only be understood once the Act is in action. Right now we're still grappling with the way it will be formulated, but I think the Act has balanced the rights very well of an individual and of the entity which collects data.
Ma'am, so you talk about like the rights and the duties of the fiduciaries and the principal as well. So principal is essentially an individual like you and I, and like the West law. So when we talk about these individuals, so there are also duties placed upon these individuals. If I'm not wrong, Section 15 talks about it. So doesn't it reverse the role of the burden of proof and the role of keeping up with the Act?
Right. So Pranjal, I think we as citizens should understand that if we are enjoying certain rights, we have certain duties or responsibilities to enjoy those rights. So those duties which are mentioned in Section 15 of the Act clearly state that the way I as a data principal, the way I will share my information, that information has to be clear. Right? I cannot give misleading information. I cannot share information which is incorrect, and especially it links to that particular right of erasure or right of correction. So if I want to correct some data which is already present or has been collected by data fiduciary, that information has to be very clearly mentioned, and it is my duty as an individual to give the right information so that tomorrow the purpose for which that information was collected in the first hand is used in the correct manner. That's the only objective of placing duties on a data principle.
Okay, so once the data finishes its purpose, it has to be erased. and that the act guarantees.
Not exactly that once the purpose is completed, it gets automatically deleted.
Okay.
There is a provision which gives you the right as a data principal to make that correction or erase it if you feel it's not being used for that purpose. So the data fiduciary itself will lay down guidelines as to how that process can take place to erase certain personal sensitive data which you don't want it to be part of, or you think that it's not serving the purpose.
Okay, so last question, not the least, as students and aware students, how can we contribute in enactment of this DPDP Act, and how can we make others aware and enlighten others?
Right. I mean, for anybody listening to this today, or students, or just individuals or part of the society, I think it's very ideal that we at least read what we are signing up for. Right. We talk about consent to be formed and inferred in that sense, but consent can only be free and informed if you read the contents you're signing up for. So I know a lot of you are into these dating apps or even payment portals. You're not reading the terms and conditions properly, and like I said, it is bent upon the data fiduciary to write the terms and conditions in that simple language so that you and I can understand as a layman. Go ahead, read, know about your rights, be aware of it, and then you can question whether things are being done properly or not. So I think that's the only suggestion I can give to people listening to us, is to read the terms and conditions of any application you're using or any service which is being provided, especially over the internet, to read, because this is related to the digital form of data collection. I'm not talking about the ones which are collected manually. Sometimes manually is also considered to be part of the DPDP bill only once it's converted into a digital form. So ideally, as citizens, you and I should be responsible enough to read what we are signing up for.
So the state has enabled us and set up kind of a platform.
Right.
It's the onus upon us to enact that act into being, and for example, as you mentioned, reading the stuff that we sign up on. That is, I think, the essential part.
Absolutely. The idea is to be aware. The idea is to be aware of your rights, and of course exercise those rights reasonably.
Thanks a lot for your time now.
Thank you, Pranjal.